Well, hello and welcome to this webinar on the Great Resignation. My name is Tom MC Smith and I'm a barrister specialising in employment law at Farrar's building. And we're here at Farrar's building. I'm joined by Jessica Bass, who's a partner and solicitor at Curzon Green, which is a law firm recognised by the Legal 500 for excellence in employment law. And I'm also joined by Corinne Mills, who's the Managing Director of Personal Career Management, who are specialists in organisational and career development. So our topic today is the Great Resignation, recruitment, retention and restrictions. Since COVID, we've seen a great deal of workplace mobility. So to give a flavour, in August 2021, LinkedIn recorded a 50% year-on-year increase in LinkedIn members changing jobs. So in this webinar today, what we're going to aim to do, Jessica is going to talk us through some points about signing and onboarding employees. Corinne's then going to talk about retention and development of employees while they're with your business. And then I'm going to finish our webinar by looking at some considerations on termination of employment. So without further ado, I'll hand over to Jessica.
Thank you very much, Tom, for that kind introduction. So amidst the Great Resignation, it's never been more crucial for businesses to be aware of the legal implications around recruitment staff. So I'm just going to look briefly at where you should be recruiting from, who you should be recruiting, and how to ensure that you're compliant with the legal requirements for taking on new employees. So in terms of where to recruit from, so the pandemic has made remote working much more common. The Office of National Statistics found that between the 19th and 30th of January 2022, 36% of working adults reported having worked from home at least once in the last 7 days. So this more flexible approach has made employers much more open to alternative working arrangements. Online job adverts, including terms related to home working, increased at a faster rate than total adverts, with home working adverts in May 2021 3 times above their February 2020 average. So this opens up a number of possibilities, including for both employers and for employees, including moves for employees to be close to family or even back to their home countries. So COVID has seen many people move abroad, either on a temporary or permanent basis, particularly with uncertainty around international travel. So just looking firstly at working remotely within the UK, so employers might be looking for the first time to agree to have employees working from home, to have employees working on a hybrid basis, so partially in the office, partially elsewhere. They might also be looking to agree flexibility in other ways. So, for example, slightly more flexible days, slightly more flexible hours, which may be to accommodate things such as caring responsibilities as well. So employees can make an informal request to their employer at any point, including during recruitment, for flexible working. And they can also make a formal flexible working request under the law. However, that won't affect you during recruitment because at the moment an employee needs 26 weeks continuous service to make this formal flexible working request. Watch this space. The government is currently consulting on this to make the right to request flexible working formally a day one right, so something that they could do on the first day that they start with you. The consultation closed in December, however, it's very much a hot topic, and we are expecting to see the move towards making flexible working the default unless the employer has a good reason not to permit it. Just some factors to keep in mind when we're thinking about hybrid and flexible working within the UK. Employers should take care to ensure that any salary and benefits package that's offered to individuals that are working from home is no less favourable than if the role was to be an office-based one. If home workers are treated less favourably, then they may well have a claim for discrimination. So it's been suggested that those with care responsibilities or those with disabilities are much more likely to stay at home rather than take an office-based role. So that might lead to claims under the Equality Act for indirect discrimination if you do offer a worse package. Depending on the location of the employee's home, then employers might consider that things like location-related salary banding is no longer relevant. So, for example, London waiting might no longer be appropriate. When thinking about the benefits that you're offering to your employees, we in our sort of view, employers are probably not expected to compensate for sort of static on-site facilities. So, for example, if you've got an on-site gym or an on-site nursery, as long as that home worker is still going to have access to them if they wanted to come into your office. You might want to offer an alternative arrangement, but I don't see it strictly necessary for those static benefits. However, if, for example, the benefit was a contribution towards a gym membership anywhere, then that should be offered to all employees. You also need to be aware that obviously when you're offering these roles that you're going to have to ensure that things like performance management, onboarding, anything like that is all going to have to follow in the same way that it would an office-based worker. So make sure it's not a case of out of sight, out of mind. The options there as well now for people to work remotely from outside of the UK. You know, we all read these articles about people sitting on the beach in Barbados doing their jobs. This comes with many risks and many complications. So if you've got an employee that you're offering a job role to who is outside the UK but doing work for your UK-based company, if that contract is governed by UK law and jurisdiction, then they're highly likely to still be subject to UK employment rights. So they'll have the right, for example, not to be unfairly dismissed, to receive national minimum wage, to receive a certain amount of annual leave, and to minimum statutory notice. However, it gets even more complicated because they may also develop rights in that host country. So what's that going to mean for your business? What rights are they going to gather? Even very practical things like your contract might say 20 days plus public holidays. Well, if the country that they're in has different public holidays, you might fall foul of that. So make sure you really define, bank holidays in England and Wales, for example. There's a risk that if you've got an employee working in another country, then that might establish a permanent base for your business there, which may well come at a tax risk. Very broadly, you might end up having to pay corporation tax in the local country based on the profits attributable to that establishment, so to that employee who might be there working for you. There's also employee tax risk, so if that employee is working there on a short-term basis, then you should still deduct tax and NI. However, if they can establish residency in that other country, you might be liable for tax in another country as well. For a practical perspective, you're going to want to look at things like your GDPR policies, if that employee is then going to be processing data in another country. So it's very complicated area, and you would need to take advice not only in this country but also probably in the country that you're looking for the employee to work from. And just briefly, just looking at bringing employees from outside of the UK here. So main route for this is via a sponsorship. So UK employers need a sponsor license if they want to recruit citizens from the EU or non-EU countries who do not already have permission to work in the UK. The rules on this have only become more complex following the Brexit transition period, and again, you definitely want to take early advice on that if it's something that you're looking to explore. So we're going to briefly look at who to recruit. So employers are now looking at a wider pool to be able to fill sort of the skills gap and the roles that are starting to exist. And there's a number of ways that people are looking to do that. We're seeing the use of apprenticeships a lot more. So apprentices must work with experienced staff. They need to learn job-specific skills, and they need to have at least 20% of their working week towards training or study. They also have a number of rights, so to be paid at least minimum wage, and they'll also gain certain employment rights, so to pay holiday, sick pay, they should be offered the same benefits as other people on similar roles or similar grades, and they also will acquire redundancy rights. I've mentioned the Kickstart scheme on the slide very briefly. It was part of the government initiative to create new jobs. The scheme has closed for now. People that have applied for funding will find out whether they're successful by the 31st of March, or they may have found out, or the job role needs to start by the 31st of March. If that scheme is successful, then there's a strong chance it might be repeated. In terms of how you can recruit from this wider pool, so we suggest that you take a look at what you're offering to new recruits, and you might well need to think outside the box with this one. At the moment, we're seeing a lot of companies invest in and really take the time to understand menopause policies, for example. It's a really big issue at the moment. According to the government report on menopausal women are the fastest growing demographic in the workplace. When I say women, I should also point my language refers to trans and non-binary people that may well be going through menopause due to changes in hormones and things like that. So employers always need to be alive to the experience of these people and support that they can offer them as well. Menopause isn't a protected characteristic for the purpose of the Equality Act at the moment, but there are calls to make it one. I'm personally seeing a lot of claims being brought in the tribunal at the moment under sex, age, and even occasionally disability headings for menopause. It's definitely a hot topic in the tribunal. And
That's a good one, isn't it? A hot topic.
Yeah. So in terms of other things that we're seeing companies offer in order to recruit people, some companies are offering things like grandparent leave. They recognise that grandparents might want to spend time with their new grandchildren and help their own children out. That could be paid or unpaid. We're also seeing companies offer things like new pet leave and doggy leave. So people are definitely getting more inventive. Companies might want to offer to upskill or pay for new employees to gain new qualifications. So if that was something that people wanted to explore, if you do that, then we'd always recommend having a training cost clause in your employment contract, so that if the employee leaves within a certain amount of time, you could potentially look to recover some of that costs. Younger and older workers may want to take advantage of things like paid or unpaid sabbatical, especially now the world's opening up. And finally, we're seeing a big drive towards mental health and wellbeing commitments, which would be useful to attract new employees. In terms of what you shouldn't do, and it shouldn't need to be said, but you shouldn't discriminate. The Equality Act protects people from discrimination even before the employment relationship starts, so it applies during recruitment as well. The Equality Act makes it illegal to discriminate on the basis of age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. So, for example, you need to be careful of the language that you're using in job adverts. So researchers found that women are much less likely to apply for job descriptions that have masculine coded language, language such as active, confident or driven. So that's certainly something that needs to be considered when you're putting out adverts and things like that. Be careful of questions that you're asking during interviews. Last week I had a call from somebody who was asked during an interview, so you have a young daughter, what are you going to do in terms of childcare and the travel requirements of this job if your husband's at work full time? Needless to say, she declined the job when the offer came in, so they've not only lost a talented employee, but they're also now facing a potential claim. In terms of employment law, it's always important to keep records of why you're making decisions, and it goes without saying that these decisions should be made on a non-discriminatory basis. You should have clear processes for hiring managers to follow and ensure that those hiring managers are adequately trained. Another point to think about is encouraging a more diverse and inclusive workforce. So research shows that workplaces that have more diverse workforces in terms of race, sex, age and culture become more innovative, more creative and more productive. So you should really take some time to look at how you can eliminate bias in the recruitment process. That's conscious bias, but also unconscious bias. I think unconscious bias is very hard for companies to acknowledge, mostly one because it's painfully enlightening, and also because being unconscious is really hard for people to recognise. There's lots of things that you can do to help, so perhaps look at things like blind recruitment. So when you get CVs in, remove age, remove name, remove nationality and gender. Employers can also really start to question their own decision making. So if you've got a gut instinct about something, perhaps think, well, why do I have that gut instinct? And also looking at panel interviews rather than individual ones, so that might help dilute any potential bias that exists. Again, really important to have policies on these sorts of things, and make sure that everybody knows about them. In terms of appealing to these groups, we just show a commitment to fostering an inclusive workforce by doing things like creating professional networks and offering mentoring opportunities to new recruits. So in terms of ensuring you're legally compliant, so you've chosen who you're going to offer the job to. It's now a case of getting them signed up. in terms of an employment contract, there's no particular formalities that have to be observed for entering into an employment contract. If I show up and somebody starts paying me to do work, then there's an employment relationship, then there's an employment contract. Employment contracts can be express or implied, they can be oral, they can be in writing. While there's no particular formalities as such for an employment contract, Section 1 of the Employment Rights Act requires an employee to be given a written statement of certain terms. The requirements of what needs to be included in that were updated in April 2020, so really in the midst of the pandemic. And all employees and workers since that date need to be given a statement of terms on or before day one of employment. So the changes that have come in since April 2020 are listed on that slide. And there is an example on our website of the Section 1 statement in its entirety that sets out everything you need to be included in that. Although it's since 2020, we're really seeing a lot of contracts and a lot of Section 1 statements haven't been updated, I think, because of the pandemic, but they absolutely should be, particularly before you offer a job to a new employee. If you don't do that and an employee brings a different claim against you, then they could bring a piggyback claim, is what we call it, for a failure to provide a compliant Section 1 statement. Your employee could be awarded 2 to 4 weeks pay for that. So it's certainly a financial risk as well. In terms of some clauses that might be specific to remote working, so traditionally your contract's going to say the place of work, which would usually or previously have been your business address. If an employee is permitted to work at various places, then the Section 1 statement requires an indication of that. There's a brief drafting example on the slide that gives you the option to include your office and also home address. There's other points that you might want to consider including for these contracts. So minimum attendance requirements, attendance to certain meetings, so if you need people to come in for training or things like that, and also the boundaries of working time. So there's a maximum 48-hour working week unless your employee has opted out of that. You should make sure that you've got mechanisms in place to keep records of anyone that hasn't opted out of it, and how staff are complying with working time and rest breaks. Failure to do so might lead you as an employee to be guilty of a criminal offence. As there's not going to be anyone in these employees' home checking when they're taking rest breaks or how often they're working, then you might want to include something in the contract that puts the onus on the employee to make sure that they are complying with these time limits and things like that. Just a note on expenses, so there's no legal obligation on the employer to reimburse any additional expenses incurred by an employee working from home. The ACAS guidance that's on working from home recommends that employers talk to their employees about who will cover these extra costs. Contracts should really specify what will be included and what is capable of being reimbursed, and if none are capable of being reimbursed, then you should really make that clear in the contract or in the policy. And then just some final points on right to work checks. So there's an obligation on the employer to carry these out before employment commences. So there's two options. You've got a manual based one where you have to see the actual document. At the moment that can be done via Zoom, but that is supposed to be coming to by Zoom or other remote methods. But that is coming to the end on the 30th of September this year. Or there is an online right to work check, but that only supports certain documents. That should be carried out on all employees before day one, not just those that you think might be from another country. And bear in mind you've got a risk of discrimination claims if you make any assumptions about a person's right to work based on their ethnicity or background. So again, make sure you have a clear policy on this. Risk of not doing so, it carries a lot of sanctions. And to say that the obligation is really, really on the employer. We suggest you include a clause in your job offer and contract holder making continued employment conditional upon establishing right to work, and also on continued employment, because you may need to carry out a follow-up check. Just a final point from me, as I say, it is a complex area, it's ever changing as always with employment law, and particularly where we're talking about people working abroad as well. So you should always take tailored and specific legal advice on it. And now I'm going to pass over to Corinne to talk about what you can do to retain those staff now that you've got them.
Absolutely, thanks Jess. Yeah, there really has been so much change, and it just seems strange that 2.5 years ago, flexible working, it still felt like so exceptional, didn't it? It was such a fact, and now it's like you know,
Yeah.
that's what we're all dealing with.
So yeah, there's definitely a push, I think, to make it more of the norm.
Well, I'm glad we're doing this in person. It's very nice to be here, even though you're at home kind of virtually. It's nice. So yeah, so what I thought I would cover is a little bit about legal contracts, a bit about the psychological contracts of what's going on with employees at the moment. Because my background with kind of working with organisations and their career developing and helping to develop their staff, we do get to have conversations with employees, things that they probably wouldn't tell their employers. So I thought perhaps what I could do is feedback some things and also some ideas of what I've seen really work well in this new workplace that we're all contending with at the moment. So first of all, let's just kind of look at the state of play. I think, Tom, you mentioned it before about, you know, just on LinkedIn, you can see 50% year-on-year increase in LinkedIn members changing jobs in a year. But you've got 600,000 people less in the workplace in the UK. You've got 41% think of handing their notice in according to Microsoft. It's really turbulent, and you may well have seen in your own teams and your organisations people upping and off or being a bit disgruntled, and so there's definitely a kind of temperature change, it feels, at the moment. Some of that is pent up, that, you know, people might have moved 2.5 years ago perhaps, but for the pandemic, so there's an element of that. But I think there's definitely some other stuff that's going on as well. And of course, you know, the reality is that's hugely disruptive if you've got people leaving. You know, it's difficult. Can you find the skills to replace them? It's costly to recruit. You know, there's an estimate there that the average cost for an employee who might be earning 25k costs them about 30k for the organisation, just by the time you've got recruitment costs, onboarding and all of those things, right? So you want to really keep people. You don't want to be doing counter offers once they've handed their notice in. I say, please stay, we'll give you some more money. You want to do something proactive. Because I think the other thing is, I think you've got some disengaged employees at the moment. Because what is going on, again, from our sense of, you know, we're doing lots of coaching in organisations at the moment, lots of career conversations. We also work with private individuals about their career. There's a lot that is going on. So people are absolutely reevaluating their priorities. I think there's nothing like being confronted with life and death, you know, that real, we all get that real fearful panic right at the start of the pandemic. Are we going to get through this? Are our loved ones going to get through it? It's been really traumatic. So people are thinking, you know, what do I want to do with the rest of my life? There's a bit of existential angst, I think, that's going on there as well. And of course, that's going to express itself through their experience at work. A lot of people are burnt out. I think they're really frazzled. I think, I hear you say about work-life balance, and they should be kind of clear, you know, they shouldn't be overworking, but the reality is people do. I mean, we've had an emergency situation going on, people are covering for team members who might have resigned, and also, you know, sadly, the state of the world at the moment is also feeding into that. So psychologically, I think people are a bit afraid, so their tolerance level is less. That's why I'm so pleased that a lot of organisations have really paid more attention to well-being, because that absolutely feels key at the moment. I think the other thing is that just the fact of working more remotely, people lose that sense of place, the kind of a culture of the organisation, and a sense of belonging, the kind of social ties that keep people, your loyalty to your colleagues, a sense of collaboration, you're all working in this together. So people feel more remote from that when they're working from home. So there's a little bit of, well, look, I'm doing this task, I'm sitting in front of a computer doing this, I'm talking to some people, but actually what's the difference between me doing it for this organisation as opposed to that organisation? Because I might be sitting in the same seat. So it's like, what's the organisation doing differently to really engage them? And there's definitely a return to office ambivalence. I was interested to hear about you talking about kind of the doggy kind of because the thing is, people have developed new habits, right? People have bought dogs and puppies, and they've gone, I go out for a walk at 3 o'clock in the afternoon. There are some really nice things actually about the pandemic that we've adopted these new behaviours. And actually, do you want to give those all up? So there's an adjustment around all of those things. So there's a lot going on in people's heads. That's combined with a very hot candidate market at the moment. I don't know if your staff are being headhunted and poached and approached on LinkedIn, but that's happening quite a lot at the moment. Combined with, it's never been easier for people to find a new job. Kind of, they're not remotely, kind of geographically restricted anymore. So all that all combines with I quit. So there's a lot that's going on psychologically with people at the moment. So what's the solution? So let's look at some things that I've seen help. So how does employee career development help? Well, the very first thing you have to do is you've got to have a career conversation with people. How are you? What's going on? How are things? And to do that in a way that is very about them as an individual. So, I hear a lot, and I think it's quite right, a lot of organisations talk about organisational purpose at the moment, being part of something that, is doing kind of better in the world, and, the whole rationale for why we're working and doing what we're. That's great, that's definitely got its place, but what about the individual's purpose? It's not just about their performance objectives, it's not just about what you want them to achieve in the organisation, it's about their career, and it's about their rest of their life. And I think, given that the pandemic has been this weird kind of blurring of boundaries between work and life, and people have to adjust around all of these things. Going forward, you've really got to pay attention to that. And actually, when you talk to people about their career, and look, not everyone's ambitious, right? Some people might be perfectly happy, or they work to live. That's fine. But when you actually ask them, they feel valued. It's not just they're not just a cog. They're somebody who kind of contributes, and actually you're interested to see how they can kind of engage more. What's of interest for them. The other thing is, of course, it kind of career development in-house, right? Grow your own talent. If it's that difficult at the moment to get the skills in that you need, right, grow your own. So do everything you can to develop your own people. It's cheaper, it's easier, you've got all that kind of knowledge that you're keeping within the organisation as well. And all of those things help to re-energise the employee experience, which has probably been a little bit jaded, a little bit samey, kind of high pressure. Just they need something that's fresh, that's new. And that sense of joint investment between you, the organisation, them, there's a sense of shared future and purpose. These are all things that are within your power to do through career conversations. And also, for going back to your point, Jess, about D&I, you want to make sure that this is available to everyone. So really important that it's not just for, just your top talent. You want to make sure that everybody's got the opportunity to develop, so you're realising the potential of that. So let me whiz through some career development ideas. So absolute career conversation training. Get your managers trained in career conversations. Sometimes they're a little bit unsure about what to do. So this is something we're doing lots of training on. But get those internal mentors, get some coaching in there, encourage people to network, and do whatever you can to support internal moves. Again, there's so many benefits. See who's a flight risk. But have a chat with them, see what else can be done. These are proactive things you definitely need to be paying attention to. Their job, right? So, I'm reading at the moment a lot about, it's not just about the job, it's about a person's capabilities, because jobs change all the time. My gosh, even in the last 2 years, the rate of acceleration has been huge. Right, I'd never done this kind of web conference before 2.5 years ago. It's new to me. So looking at lots of different projects, people can get involved in research tasks or doing a quality initiative. Maybe they can train or mentor others. Maybe they can be an internal champion for well-being or menopause, advocate. Look at some ramps for promotion as well, because in flatter organisations, it's much harder for people to go from here to them. They don't always even want their manager's job. So actually look at ways in which they can really think laterally. Again, that's helping your agility in terms of your organisation, keeping on and growing your future leaders. And then, of course, all your formal learning opportunities as well. So I'm going to kind of skip through this a little bit because I want to go on to just a kind of a case study at the moment, which I think is really illustrative of where this made a difference. We'll send the slides to you, to everyone after, so you can have a look. But this was a really good case in point of an organisation. It's a social care organisation who, with the Great Resignation, had huge challenges. Right? People were really burnt out in their sector. They had a number of people leave. Right? Amazon warehouse was actually a major competitor. They were offering more money, kind of, in some respects, less stress. They had to keep their people. Because that's the whole, sustainability of the business. The sector turnover for this business is 31%. So it's really wide. So what was their strategy? So the strategy was create conversations, right, in the first instance. So we went in, we trained the board, looked at the managers, and also there was an in-house career coaching program, developing some talent pools, doing internal mentoring, project learning opportunities. So a whole range of different career initiatives, career development initiatives that were kicked in. And as a result, I think this was phenomenal. There was a lot of work that went into this, but their organisational turnover is 13% as opposed to 31% sector average. That is a huge transformation for their business. There was a smarter spend and better ROI on the learning development. 73% of those talent pools were then promoted or had their role enhanced. And I think just the other thing that I would point on is that, again, the D&I was a very important part of this. 15% BAME representation that they had, but actually 16% participation in these career development opportunities. So it's absolutely win-win. They've developed a compelling employee value proposition so that they can go and recruit on this basis. People are happier, they've won awards for it. It's a really great result. What was the difference? Is actually by sitting down with the individuals and saying, what's important for you for the career? Some are ambitious, some are not, but actually paying attention to everyone made the big difference. So there we go. Get this career conversation started. Really develop your employees and help people wherever they are to progress their career.
Thanks very much.
Thank you.
Great. Well, Jessica was mentioning some of these contractual provisions that put the onus on the employee to be policing themselves in terms of the hours they spend at their desk or where they work from. Do you find that this kind of ongoing development and those kinds of conversations can help with that sort of productivity and the motivation to be working well from home?
Yeah, absolutely, because people aren't always working efficiently. The thing is, sometimes about remote working, it gets very functional, gets very task focused, and sometimes, a conversation is, well, why are you working? And if the individual isn't sharing the hours that they're working, if they don't have an opportunity to just have that discussion, then sometimes the manager doesn't know, because again, sometimes people live on their own, right? I think this is a a real difficulty about some of remote working is that a lot of people like the social structure of being in a shared environment, and they might not have lots of other things going on. They couldn't go out in the evening for a long part of that. So yes, so definitely things like that. There's so much of people's employees' experience that could be so much better. But they haven't got the opportunity to discuss it, and nobody asks. So I think this opens up the opportunity to have conversations.
Great. Well, thank you so much, Corinne. For the last part of this webinar, I'm going to be talking a little bit about steps that you can take to protect your business when employees exit, or how to not have a total nightmare, as I've called it. Because situations like this, where an employee might leave and take with them information that's confidential to the business, or might leave and set up in competition with the business, can be a real problem. And in some cases, it can be fatal to your business. So it's really worth having a good think about steps you can put in place, systems, contractual provisions, to avoid any situation from occurring in the first place. So we're going to have a little look at that. We're going to look at the law first. Firstly, looking at contractual business to protect business interests, and then having a very brief overview of the law relating to confidential information and the employee's duties there. But then we're going to go back to some of the more practical things that we've been discussing, and think about practical protections that you can put in place aside from the contract, and the exit process as well, thinking about how and when you should use garden leave, and how you might make use of the exit interview. So we're looking here at the Coca-Cola vault. So this is the Coca-Cola recipe is generally thought of as being the prime example of a recipe, an interest to the business that needs to be really carefully protected. And I'm told that the Coca-Cola recipe is kept inside this vault in the Coca-Cola Museum, and something like 5 people have access to it. But every business has some assets, some either confidential information or some ownership over assets in the business that are going to give it an advantage on the market. And what's really important is that you protect these and you make sure that there's not going to be a risk to these kinds of things that can be of value to your business when employees move on. So for those of us that aren't used to dealing with these contractual provisions, the main ones really are the following. So requirements that employees don't engage with competitive businesses, that's a non-compete clause. Requirements that they don't solicit any client of the business, non-solicitation clauses. And requirements that they don't use or communicate any confidential information, so confidentiality clauses. Those are perhaps the 3 main ones. There are other restraint clauses that are commonly in employment contracts, but that gives you a flavour of what we're discussing. The key principle to keep in mind when you're drafting these kinds of restraint clauses is that contractual clauses in restraint of trade are only enforceable if they're reasonable. So contractual clauses that prevent someone from using their skills on the labour market are only enforceable to the extent that they're reasonable. So as a general rule, the law strikes a balance. As a general rule, any contract that stops an individual from using their skills on the market is unenforceable. But the other side of the coin is that the law also recognises that employers should be able to protect these interests of their business, and they should be free to contract in order to do so. And that is an exception to that general rule. So employers are entitled to protect their interests by way of the contract. But the upshot of that balance is that these restraint of trade clauses need to be drafted no more widely than is reasonable. And in order to be able to justify a clause, the employer needs to be able to identify the business interests that they are seeking to protect with that clause. There are three broad categories of business interests that the courts have recognised historically as capable of justifying a restraint clause. First is trade secrets and confidential information. The second is trade connections and suppliers and customers. And then thirdly, more recently, actually, this has been recognised by the court, that businesses have an interest in their workforce skills. So the skills of their employees and the stability of their workforce. These are all interests that can be protected by restraint clauses. So it's really important when you engage an employee at that stage, right at the outset, to be thinking through the interests that you need to protect. So you can ask the following questions. Consider the nature of your business. So what are its key interests? That could be your client list. It could be a stable workforce. So if you have a business that relies on particular skills for the employee, or on stability, people not moving about every few years, that could be a legitimate business interest to protect in the contract. Or it could be your intellectual property. But you need to have a think and actually identify specific interests that you're seeking to protect. Then consider the particular employee's position. So which of those interests need to be protected from that particular employee? What are they placed to access? What might they be placed to take with them when they leave? And then once you've thought through those two questions, you can then think what provisions are actually necessary. But a restraint of trade clause should be specifically tailored to that particular employee's circumstances. So it is quite important to avoid a cut and paste approach, particularly for more senior employees. Your contractual term is less likely to be enforceable if you've taken restraint of trade clauses and applied them uniformly across everyone's contracts. So do tailor them to this particular employee and his or her particular position within the business. And they also need to be rationally connected to the business interest in question. So looking a little bit more closely at that, just using this example, you might have a contractual clause that says during the term of this agreement and for a period of 12 months following termination, the leaver shall not engage in any capacity with any business competitive with the company's current lines of business. So that's a slimmed down version of a fairly common non-compete clause. You might think, what's the matter with that? It's preventing someone from setting up in competition with our business. But you've got to think, what interests are you actually trying to protect with this clause? And is it actually necessary to prevent someone from going to work with a competitor? And if you think about that question, the answer might be that you're actually trying to protect your client base. You're trying to prevent this person from going and stealing your clients when they move on. So if that's the interest you're trying to protect, how about this term? During the term of the agreement and for a period of 6 months after termination, the leaver will not solicit, canvass or entice away any person, firm or company or organisation which is dealt directly with the leaver in the 12 months prior to termination. So do you see that that's much more proportionate to what you're trying to protect? So for a start, it's only 6 months. It's no longer than it needs to be. It's also a requirement that they won't solicit your clients rather than preventing them from working at all for a competitor. And also it's limited in its scope in that it's clients that that person has directly dealt with. And so a much more limited contractual term like this is going to be viewed by the courts. It's much more likely to be enforceable. And that's going to put you in a much stronger negotiating position if you are in a situation where you have to rely on a restraint when someone moves on. So then, looking at confidential information. So this person on the slide has built their own Gringotts bank vault. So you know the one where the goblin sort of strokes the door and it opens up from Harry Potter. So he's built his own vault. But I suppose the question we're thinking about is how do you, as a business, build a Gringotts Bank vault for the information that's confidential to your business? So looking again at a brief overview of the law in this area, there's three broad categories of information, confidential information, that the courts have recognised. The first is known as trade secrets. And what we are talking about when we talk about trade secrets are things that properly so-called are confidential information. So another term might be protectable confidential information. Things like recipes and secret formulas, like the Coca-Cola recipe. Manufacturing processes, client lists fall under this category, and things like pricing structures. So you have on the slide some of the tests that the courts have laid out in terms of what might be considered a trade secret. So then it needs to be information, the use and dissemination of which is likely to harm the employer. And in some of the cases, you see a distinction between objective knowledge, so something hard that the business can actually consider is their property, as opposed to subjective knowledge, things that are in the employee's head, their skills and their abilities that they've built up. So that sort of thing can be considered trade secrets. A further helpful test is in the Trade Secrets Enforcement Regulations 2018. And this is quite important to have a read of if you're involved in an HR function, because essentially it's a statutory regime for protecting trade secrets and gives the employers options essentially in terms of how they enforce their right to confidentiality. And it operates alongside the existing common law protections. But for our purposes here, it contains quite a helpful definition of trade secrets. So it doesn't replace the common law definitions that we've looked at. But what it says is trade secret is information which is secret in the sense that it's not as a body in the precise configuration and assembly of its components, generally known among or readily accessible to persons within the circles that normally deal with this kind of information. It has commercial value because it's secret, and this is important, and we'll go on to think about this, it's been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. The second category, which falls short of trade secrets, is what's often known as know-how. Know-how, you can think of that as the knowledge or the skills that the employees built up in the course of their employment. So it might be information that's confidential to the employer when they've imparted it to the employee, but then it remains in the employee's head just as something they've learned. And obviously they can't unlearn that, so they're going to take that with them if they move on to a different employer. And then finally, the third category is trivial information. It might be confidential, but it's trivial, or it's in fact publicly available, even though the employers perhaps put it together in the course of their business. So just to illustrate that distinction, this is Anakin Skywalker, and he's been trained by Obi-Wan Kenobi. And there might have been things while Anakin was being trained that were properly so-called confidential. So things that were trade secrets. So perhaps the proceedings of the Jedi High Council would be something that Anakin cannot then take and use as he wishes. But there might be other things that Anakin has just learned and that form part of his skills and abilities, perhaps how to use a lightsaber, how to use the Force. That might be categorized as know-how. So how does Obi-Wan enforce his rights to confidentiality? That's what we're going to look at next. During employment, the employee has a duty not to make use of the information that they acquire in their employer's business and use it elsewhere. So that applies to trade secrets, but it also can apply to a lot of what we would call know-how. It wouldn't apply to trivial information or public information, But an employee has a duty of good faith and a duty of fidelity, so they can't then go and use the information that they've acquired for other purposes. And some examples in the cases of what that's included, it includes an obligation not to make or memorize a list of customers that they then intend to go and use after their employment. And it also includes an obligation not to take a list that might be available elsewhere, but the employer has actually put together, and then take that list and go and use it elsewhere. The situation is slightly different after the employment has terminated, and this is what we're thinking about today, really. After the employment relationship has ended, an employee still has a duty not to disclose or make use of information that has the status of a trade secret. But that obligation would not apply to what we've been calling know-how. So it needs to be a trade secret in order to be enforced, essentially. That's an implied duty, so there's not a strict requirement for there to be an express term, although I'm not recommending that you leave out an express confidentiality clause in your employment agreement. But the thing about that duty, it's very difficult to enforce. So if an employee does leave and goes to, say, a competitor, it's first of all very difficult for you as a business to actually know when they're imparting confidential information to their new employer. But it's also quite difficult for the employee who's gone elsewhere to know when they're using confidential information and when they're just using the information that's in their head. That can be quite a difficult line for them to draw. So courts recognise that these can be quite difficult duties to enforce. And so for that reason, this is a situation where a non-compete clause, like the one we were looking at a little earlier, can be justified in order to protect the interests of confidential information. But that said, much will depend on the context. So what the confidential information is, what kind of employee you're talking about, how they were positioned in the business, and any non-compete clause that you're using to protect confidential information needs to be reasonable in its scope and in its duration. So you do still need to think very carefully about drafting these provisions carefully so that they'll be enforceable. So that's a very broad overview of the legal duties that employees own, which could be very helpful in a situation where employment is being terminated, especially if they intend to move on to another competitor or another business. Something that I hope has come through is that it's very important to take reasonable steps to protect confidential information, not just by way of contract, but by way of the processes and the systems in your business. That's important for a number of reasons, really. Firstly, it's the best way to avoid any data breach, but also any situation where someone might disclose confidential information after employment. But also, as we've seen, for the 2018 regulations to apply, for it to be classed as confidential or trade secret within those regulations, the reasonable steps have to have been taken for it to fall within that definition. So some reasonable steps that you can take. The first step really is to actually identify the information that you're talking about. So in order to ring fence your confidential information, we need to know what's in the fence in the first place. And then we need to think about steps that we can take to actually close the fence and protect it. Every employment contract should have a confidentiality clause and intellectual property clauses. But a well-drafted employment contract will often include a schedule that actually sets out what's included in the confidential information. It doesn't need to be an exhaustive schedule, but it lets you point to exactly what we're talking about and exactly what you're trying to protect. And then it's very important to audit and review and update the list so that it's constantly in date. And the final tip is just keep an eye out for updates on the Trade Secrets Enforcement Regulations 2018. Because this point about reasonable steps is bound to come up in the case law. So that will give pointers as to what steps a business can have in order to protect confidential information. As I've said, the best measure really that a business can have in place in order to avoid any situation where there's a dispute about disclosure of confidential information is to just maintain a culture of confidentiality within the business. And that's really just doing simple things. So mark documents as confidential if they are confidential. Don't pass confidential documents around the office because then you're going to have a much more difficult time arguing that they are actually confidential if they've been widely shared. Only share parts of the whole picture with the employee that they actually need to know. So, for example, if there's a manufacturing process, perhaps you don't need to share the entire process with every employee. Perhaps you can just share parts of it, and then they wouldn't be able to share the full picture with a competitor. IT security is of crucial importance, so use passwords, encryption, permissions, and alerts. And then coordinate with IT on exit arrangements. So it might be a case where you need to return the IT to the business and think about wiping it, or perhaps quarantining computers on exit. Garden leave can be a very helpful tool to protect confidential information. So for a start, it can stop a leaver from actually stealing information in the first place, particularly if there's been a dispute or employees have fallen out. But it also allows your business in that time when they're on garden leave to acquaint your clients to the replacement, rather than having a situation where the employee is going straight to another business and hopefully trying to take some of your clients with them. And it also allows you to take steps if someone's intending to set up in competition with you, to prepare for that situation. So some things just to think about in terms of garden leave: you need to make sure that there's a contractual term enabling you to put people on garden leave. If you don't, you run the risk that the employer will be released from any restrictive covenants that they're under, because potentially it could be a repudiation of the contract, and so they wouldn't be bound by any post-termination restrictions. Ideally, there should be an exclusivity clause requiring them only to work for you, so that they don't then go and use their garden leave to work for a competitor while on your payroll. And the final point to make is just think about outplacement and the measures you can take to support the outgoing employee while they're on garden leave. Corinne, that's probably some area that you've got some experience.
Well, absolutely. It just makes a huge difference. I mean, we kind of do outplacement for people who are exiting, but I think when things are fraught, when you're exiting, it's in everyone's interest to make it as positive and constructive as possible, and actually people feel supported on the way out. That can help you with negotiations as well.
Yeah. We see it as a very common provision that's being included in settlement agreements at the moment. When you have got a dispute, a lot of employers are paying towards outplacement, which helps.
And finally, just consider reducing or releasing from restrictive covenants. So if there's going to be a period of garden leave, that might be a point to renegotiate the restrictive covenants that they're under. Jessica, you've had some experience of that.
Yeah, absolutely. We're seeing a lot of employers tending towards releasing people from the blanket non-competes so that they can then focus on protecting their legitimate business interests, which at the moment we're really seeing is suppliers. Any company that seems to have been impacted by sort of supply chain issues and things like that are really trying to protect that at the moment, even perhaps over sort of blanket non-competes.
Yeah. So if you have wide and potentially unenforceable non-compete clauses in your contract, garden leave and also the exit interview, might be an opportunity to try and protect your business through negotiation rather than trying to rely on contractual clauses that might not bite. The exit interview is also a crucial time in terms of protecting your business interests and confidential information. Again, be proactive about thinking about things like outplacement.
Because I think as well, it's the whole thing about, you increasingly organisations want people to be brand ambassadors. They want kind of to build an alumni because they might go, but maybe later on they might come back. Mm-hmm. So you want to kind of handle that as positively as you can.
Yeah. Obviously, do the key things. Ensure that all the documents, information, property are returned. It's often helpful to ask a leaver to sign a declaration that they've done that, because that focuses the minds that they've actually searched for it. If appropriate, require them to return their own device if there's confidential information belonging to your business on there, and actually remind the leaver of their duty of confidentiality, because often a leaver might not realise that they're under these obligations, and it can be a far more effective way to ensure that they don't do anything detrimental to your business if you have a conversation about their obligations towards you. And again, as Jessica was saying, the exit interview can be a time to just revisit and renegotiate any restrictive covenants, just to focus them in on exactly what you want to protect and what this particular employee might be able to take with them. So thank you very much for joining us. I might have said at the start, but do feel free, if you have the text box in front of you, to answer any questions. We'd be quite happy to answer them. If not, you have our email addresses on the screen, and I think I speak for Jessica and Corinne that we'd be absolutely happy to receive any queries, and if we're able to answer them, then we'd be delighted to do so. Do you have time for some questions now?
Yeah, absolutely.
I think we've got some questions that were prepared in advance, or sent in advance. Someone asked, if we don't have the employee sign the contract, does that mean that they don't have to give us notice when they go, or can they just change things, or can the business just change things like their bonus if they don't?
Well, as long as you've given the employee a copy of that contract, and they've turned up and started work for you and accepted the salary, then they're deemed to have accepted the terms of it. But obviously, practically, you're much better to get a signed employment contract from that employee. They should be giving you that notice of providing that they've had a copy of that. And as an employer, you can potentially go down the route of breach of contract if they don't. But not having that signed document is going to put the evidential burden on you, I think, to show that they've had it and that they've read it and that they've agreed to it. In terms of then the employer messing around and starting changing things, I think that would be particularly risky if you've given somebody a copy of that employment contract. You might end up with a constructive dismissal claim if you change things without consultation. What we'd say is, obviously, one, make sure that you've got a signed contract, but perhaps make things conditional upon returning a signed contract. So if you're giving someone a bonus, if you're giving someone, some other sort of benefit, perhaps look at saying, well, you can only have it as long as I get that signed document back. And what we're also seeing at the moment is obviously with things like DocuSign, it's really easy to do it. Practically, it should be quite easy for somebody to return a signed document to you, and if they're not, then perhaps that's when we start having those conversations that Corinne mentioned about what's going on. Are they looking for something else we don't know? Because another thing that we've seen is with these restrictive covenants that Tom was talking about, another time that it might be useful to introduce them is if you're giving someone a promotion, if you're giving someone a pay rise, if someone's a bit reluctant to sign that, maybe that's an indication of when to have that conversation. Yeah, absolutely. Are they that slight risk that you mentioned? We don't know.
Yeah.
Yeah.
We've got another question here, which is, I think our managers are a bit nervous about having a career conversation with their staff. They're a bit protective and think that if they talk with them about their career, it might encourage them to leave rather than to stay. Any tips? Sorry, I'll put a question for you.
Yeah, it's true. I think people are nervous. It's like, well, if I don't ask, well, we can just pretend nothing is happening. But, you know, and then you've got managers who say, you know, the notice is handed in, and they say, why didn't you talk to me about that? Why are you leaving? Well, I wanted more of this. We could have given that to you. But you've got to ask. But I think it is fair to say that a lot of managers are a little bit unsure about how to handle it. We do a lot of training for managers in this, because I think there's lots of things that managers can do that are free, that are low cost, that are good for the individual, good for the organisation, really practical things that they can apply. So I think there's just a bit of a structure that they need for those career conversations and a bit of a framework, and keep them away from appraisals. So it's not about performance objectives, this is a bit more strategic for the individual. So yeah, so you definitely need to have it. It doesn't change the situation. If you don't ask, it doesn't mean the situations are very different. But I think it is worth thinking about some training for the managers.
And obviously, Tom, we spoke about confidential information, but what should you actually do if you find out someone's using confidential information after?
Yeah, so we haven't really talked very much about enforcement, because hopefully you don't ever get to that stage. Hopefully we avoid the dispute in the first place. But the primary tip really is just take legal advice very quickly. Because if it came down to it, what you'd be looking at was applying to the court for an injunction to prevent the outgoing employee from doing what they're prevented from doing by the contract. And you can also claim damages if someone has set up in competition using your confidential information or in breach of their contract. The damages are it's very difficult to prove the loss to your business. So ordinarily, what you'd be looking to do is get a court injunction. But do that, take legal advice very, very quickly, for two reasons, really. One, obviously, time is of the essence, just in terms of the impact on your business. But two, the longer you leave it, the less likely it is the court is going to grant an injunction. Great, well, thank you very much for joining us. That wraps up our seminar. As we said, I'm quite happy to be contacted about anything that's been raised in this seminar, and hopefully we come across some of you in the future. But thank you very much for joining us.